to law in the constitution, or are we now going to say 191 में stylistic है, but Article 14 में stylistic नहीं है? How do we read that then?
It was specifically in response to my Lord's question that why is this word subject to the constitution used when it's automatically.
अब तो subject to law पर आ गए हैं ना?
जी, मैं subject to law के हवाले से मेरी गुजारिश ये है कि an addition is made, because that is not something that is automatically understood, because there can be rules with constitutional backing that do stand on a higher pedestal than statute. That is a possibility. But as far as the rules made under 191 is concerned, the addition of the words "and law" when compared to other kind of constitutional rules, that is a significant difference.
Kindly take a look at Article 99.
Ji, sir. The federal government's...
Yes. Kindly take a look at Clause 2 as it stands now.
The federal government shall, by rules, specify the manner in which orders and other...
I don't have to read the rest. Now, here again, direct rule-making power conferred by the Constitution on the executive branch.
Yes, sir.
Obviously subject to the Constitution, but not subject to law. I'm asking you.
Sorry. Yes, of course, subject to the Constitution.
So, where the executive branch is concerned, we are to say that the rule-making power is on a higher pedestal, even though under our parliamentary democracy, for example, federal government is collectively responsible to the National Assembly. In fact, the Prime Minister and so on, they arise out of Parliament itself. It's not a presidential form of government, it's a parliamentary form of government, Westminster style. So there, the executive branch is put on a higher level, that even though they arise out of and are answerable and accountable to Parliament, in their rule-making power, they can just ignore any law. And that, in fact, Supreme Court can't, although it is a separate branch of the state. Supreme Court, because law, you say, is an enabling power, and therefore the Supreme Court is not the master of its own house. The master of the roster is Parliament.
Well, Lord, I wouldn't say that they are master.
Is this a constitutionally viable argument?
I wouldn't say they are master of the roster, the Parliament.
Because I asked you, you specifically have said, law can repeal the Supreme Court rules.
Yes.
What more is there left?
Yes. That doesn't automatically, my humble submission is...
That's a matter of competence here. What more is left?
My Lord?
They can say, we throw out your rules, 1980, so that's like 43 years standing rules. We throw them out. Out you go. We make our own law. We are the master of the roster. And in our rule-making power, we empower the federal government to do whatever we wanted.
That, if they did that, my Lord...
आप देखिए ना, this level, at the highest level, committee, no committee, everything, they are... And I'm going to use something very strong, but I'm saying it with all deliberation. This argument reduces the Supreme Court. All due respect to Parliament, it reduces the Supreme Court to a hapless plaything for Parliament. This surely cannot be right.
Lord,
this surely cannot be a constitutional interpretation. What do you say to that?
Lord, I would humbly...
Please don't say that it can be a hapless plaything of the Chief Justice. Don't say that.
I think I beg to differ with my colleague on the Parliament being the master of the roster. It could have been had the Parliament kept that power with themselves.
Yes.
Had the members of the Parliament been in charge of this, yes, we could have said that they've become master. They've actually left it to us. So instead of saying that the chief is the master, they're saying 6 people or 3 people or 5 people are the master. So it's not them. Had they retained it with them, then they could have...
The choice is ultimately theirs. That's the problem.
My Lord, with respect, I look at it...
The committee is the creature of Parliament.
If they can do this, and we say that you can do this, there's
then
a
they can do that also.
Tomorrow when they do
That
that,
is the
we'll
thing.
strike it
I'll
down.
address this. I'll address
every,
this.
Okay, but-
every law also has to be seen in its historical context. The master of the roster and the powers exercised probably were viewed by the representative of the people to have been exercised against their interests. So that is why there was a need for the law. And we cannot ignore or just turn a blind eye to the historical context of why it was so necessary.
I mean, somehow
My lord,
we
there
sort of
has to be-
referring to the parliament in a bit of a derogatory sense. You see, as if they're the Indians or some people outside somewhere. You see, it's the parliament, and parliament is a house which represents the people of Pakistan. So people of Pakistan, through their representatives, cannot have a right to say how the Supreme Court has to function. It is, we are trustees doing work for the people of Pakistan. They can't turn around through parliament and tell us how to regulate things. So even if the word dictation was used, I would say, yes, people can dictate how we're supposed to do. I mean, who are we? We're just trustees.
The people can dictate.
It
the
is not
government
just
can't.
the voice of
And-
the people.
But the parliament are the chosen
and
representatives
the people have
of the
already
people.
spoken
It
in
is
terms
not.
of the
It is not
Constitution.
just.
So if the people want to speak again, obviously, people have given the Constitution. Let them say so in the Constitution.
It is not.
32 or 34 MNAs sitting in the parliament, they don't speak for the people. They speak for a party for the reason that the majority is the government actually. So it is rolled into one. The executive and the parliament are rolled into one.
Speaking
If-
for my.
if-
Speaking for myself.
If
Let us not.
if the people of Pakistan have to have their will, yes, it is their country. They have given the constitution. They have a right and they have the power to amend it. The moment they amend it, the entire argument finishes.
My lord,
आगे
may I-
बढ़ें,
may
आगे
I-
बढ़ें।
जी, I just wanted to say to.
Are you concluding now?
Just 10 minutes. Sir.
Ji.
As far as this is concerned, just to wrap up the relative primacy of statute and rules, my submission would be that no doubt that the two spheres, legislative competence and infringement of judicial independence, those are completely separate issues. So if Parliament has legislative competence to even completely repeal and modify and bring in new Supreme Court rules, it will nonetheless
Will it not be subject to anti-55?
Sorry, sir.
If they legislate a new law, the parliament, will it not be subject to anti-55?
As far as creating additional jurisdictions is concerned, yes. As far as practice and procedure is concerned, my submission has been that it doesn't depend on NT55. But what I'm saying is that if Parliament does repeal the Supreme Court rules, it brings in its new rules, your lordships will check those rules on the touchstone of Article 10A. And if there's anything in those rules that effectively impairs your lordship's independence, then your lordships would be free to strike it down. It is, for example, sir, that Parliament has competence to pass any criminal law. But if Parliament passes a law that anyone who looks at us funny will be hung, your lordships would not examine the case on the basis of legislative competence. Your lordship would strike it down as being contrary to Article 9 and so on and so forth. So those two aspects have to be segregated. Now, if to move on, sir.
So you mean that door can be open, but scanner has to be installed?
Yes, if the opening of the door is misused, then your lordship can step in. Now, as far as independence, that brings us to the independence of judiciary, sir. It is exactly, and the opening of the door, wala jo provision, as far as I understand it, it's very different from legislative competence. Let's say a law seeking to regulate a trade is challenged on the touchstone of Article 18, or a law imposing a property tax is challenged on the touchstone of Article 24. This court will not say that, oh, if we open the door, tomorrow they might take away all the property, or tomorrow they might prohibit in the guise of regulation. Your lordships will examine the substance of
rather
the law.
than going into vague examples, what this law does not do, which is significant, I don't know if I've noticed it, its significance or it's not significant, is we have this whole concept of mandatory and directory provisions. Now, this law does not stipulate anywhere whether consequences of not strictly abiding by it. So maybe Parliament, in deference, did not say maybe the next step, any case so decided in contravention will be considered quorum non judice or something. They could have done that. Then it would have become a mandatory. That's my understanding. I may subject to correction. Here it still has left room, whether we call it wriggle room or whether we call it interpretation of the 3 senior judges of the Supreme Court. It's not taken away everything, because there's no consequences that, okay, there may be situations where it's not practical or feasible or for whatever reason. And I don't know, I don't want to kind of envisage all these situations. I have this law before me. It does not clearly stipulate that if you don't strictly abide by each and every letter of it, there are adverse consequences either for the judge, or it constitutes misconduct or something like that. So nobody has touched upon this point at all, and everybody is assuming that it is extremely mandatory with grave consequences if not abided by. Now, if we take a sort of a middle ground and say, yes, it is not mandatory to that extent, but it is a law, and you would, I mean, like so many laws say, take the Anti-Terrorism Act. Has it ever been abided by? Trials completed within 90 days. NAB, I think, law says the same thing. Now, is the judge removed? Is the judge sent into jail? Is he disqualified? Trial continues. I mean, you know, that's kind of, you know, showing the beacon, the light, okay, this is what you should do. But many times it's not done. In fact, under those laws, I have not come across a single case where they have been strictly abided by in terms of time. And Parliament has always, throughout, in various statutes, fixed timelines, because they want, presumably, people's issues decided quickly. But they cannot be without prescribing the consequences. So, absence of consequences, nobody is touching upon. Do you have anything to say on that?
I would submit that ordinarily, of course, one would expect your lordships to follow the law that has been.
There is a very serious consequence. Even if each and every provision of this law is, other than the appellate provision, maybe the practice and procedure part is read as directory, and the 3-member committee says, well, out it goes, we don't care, we are not going to follow it. Will they not be in breach of their oath of office?
Lord,
the oath of office says they are bound to act.
I wanted to hear something from you. I mean, it can be the bloody-mindedness of the Chief Justice or of all 3 of us.
Even if it's directory, it's directing judges who've taken an oath of office. Then are the judges going to say, well, this is not law, and we won't abide it, and I don't know. How it goes, our oath of office.
My submission was,
very difficult in a bad
my submission is only this, that obviously if a law is in the field, one would expect that the judges of this court will abide by the law. What the difference between mandatory and directory is only this, that if there was not, in some case, full compliance with the law, it would not automatically mean that in that case, the entire judgment goes or it falls apart.
Let's take the constitutional provision, Article 199(4)(a), which is not a statutory provision, it's a constitutional provision. Is it abided by in every case? 4A, 6 months following the day from which it is made, the order? Yes. Now, let's live in the real world. I mean, how many times the orders are still subsisting? And where the government or someone say, okay, 6 months over, I'm not going to follow this order.
If I can move on from this, sir. Sir, there's another aspect of this that my learned friend before me has already pointed out, that Article 202 is framed in the identical terms as Article 191, except that it says that the rules may be made for the High Court or for the subordinate court. Now, independence of judiciary, of course, is applicable equally to the lowest magistrate and this court. There's no difference between the two. So, if there cannot be any...
Sorry to interrupt, but I just put it to you a little while ago because over there were specific legislative competences in relation to civil procedure and criminal procedure. That line of reasoning, if advanced, would have rendered redundant legislative competences expressly conferred. So clearly, seems to me that the position of which one is it? 201.
201.
201 is
202.
202, sorry, is perhaps different from 191.
My lord, once again, I am drawing a clear divide between independence of judiciary and legislative competence.
I'm not talking of independence. I'm talking of legislative competence.
Yes. So I'm talking of independence of judiciary because I've dealt with the legislative competence already. As far as independence of judiciary is concerned, if it is argued that allowing the statute to override the Supreme Court rules is destructive of independence of judiciary, then that will apply in full force to any statute that regulates the procedure of the high courts or the civil courts over the existing rules. Now, those rules, sir, are the West Pakistan High Court rules as applicable in the different provinces. In Sindh, there's the Chief Court, original side rules. There is the various orders of the CPC.
No, Mr. Salahuddin, listen here, I'm here.
Sorry.
क्या आप कोई ऐसा प्रोसीजरल लॉ साइट कर सकते हैं जिसके नीचे रूल मेकिंग की पावर दी गई हो?
हेलो?
Can you cite any procedural law जिसके नीचे रूल मेकिंग की पावर दी गई हो?
Civil Procedure Code.
Civil Procedure Code is a blend of substantive and procedural law both.
So as is this law?
प्रोसीजर लॉ की बात कर रहा हूँ. कोई ऐसा दुनिया में प्रोसीजर लॉ है जिसके नीचे रूल मेकिंग की पावर दी गई हो?
My lord, my submission is that this law also is a blend of procedural and substantive, like the CPC.
आप ये कह रहे हैं subject to constitution and the law. वो लॉ जो उसका जिक्र है वो सब्सटेंटिव लॉ है, ये प्रोसीजर लॉ है. अगर आप उसे प्रोसीजर लॉ कंस्ट्रू कर रहे हैं, अगर आप उसे प्रोसीजर लॉ कंस्ट्रू कर रहे हैं, तो क्या उसके नीचे मजीद रूल मेकिंग की पावर दी जा सकती है? क्या दुनिया में कोई ऐसा कानून है कि प्रोसीजर लॉ के नीचे रूल मेकिंग की पावर दी गई है?
Salahuddin, Article 202 is relevant to the high courts and the practice and procedure made by the under the constitution and the law. अब ये जो आर्टिकल 199 की अपील होती है वो भी तो कॉन्स्टिट्यूशनल प्रोविजन है ना. 199 के अगेंस्ट कोई अपील है कॉन्स्टिट्यूशन में?
Apart from what is written in 185, नहीं है.
No,
नहीं सुनिए 190. Please let me complete, sir. Please. आर्टिकल 199 की अपील है कॉन्स्टिट्यूशन में?
Directly.
नहीं है. तो लॉ रिफॉर्म्स ऑर्डिनेंस के तहत कैसे दे दी फिर?
That is my case. Even
लॉ रिफॉर्म्स ऑर्डिनेंस में the provision is that if at original stage one appeal is provided, then intra-court appeal does not lie. In case there is a direct writ against the order and there is no appeal in between them, then the intra-court appeal lies unto the divisional bench. और ये कॉन्स्टिट्यूशनल प्रोविजन है, तो आर्टिकल 199 की तो कोई अपील नहीं है, तो फिर वो भी नहीं दे सकते ना.
और जरा बात मेरे कलीग की बात अगर मैं आगे ले चलूं, वहाँ तो फिर भी अपील थी. अगर आप अभी भी हमारे जजमेंट्स हैं कि एक ऐसे केसेस में आप आ सकते हैं डायरेक्टली अंडर 185 ऑफ द कॉन्स्टिट्यूशन, वहाँ तो अपील मौजूद है, आईनी अपील है, उसके बावजूद एक इंटर कोर्ट अपील दे दी. तो यहाँ तो वो दरवाज़ा भी नहीं है. तो वो मे बी दिस इज ऑन हायर पेडिस्टल दिस केस, taking what my learned brother has said further.
The one argument that was made by Bhandari Sahab on this was
नहीं, वो फिर जो कॉन्स्टिट्यूशन की अपील आई है वो कैसे आई है? मतलब वो फिर अगर वो भी गलत है ना, 199 की अपील फिर नहीं होनी चाहिए ना. लॉ रिफॉर्म्स ऑर्डिनेंस
if the logic is against section 5,
this is the logic
has to apply to the law reforms
1972 का लॉ रिफॉर्म्स ऑर्डिनेंस पे रिडंडेंट होना चाहिए ना.
And the defense, the argument that was raised by Bhandari Sahab on this was the law
72
reforms
ordinance was saved in the constitution.
जी बिल्कुल उसी पे आ रहा हूँ सर. That the law reforms ordinance was saved by Article 269 of the Constitution. But as your lordships have held in full courts, that those provisions 268, 269, 270 are for retrospective validation. They do not prevent that law from being struck down on grounds of present conflict with the Constitution. Benazir Bhutto ke case mein and Iftikhar Mohammad Chaudhary ke case mein.
Law reforms ordinance is a continuation of the letter patent law. That was a totally different letter patent के against जो है वो इंट्रा कोर्ट अपील उस लॉ में लाया करती थी और उसी को उन्होंने incorporate इसमें किया and then subsequently it was saved under Article 270.
Yeah, your lordship is absolutely.
That's a totally different.
But your lordship will appreciate the letters patent appeal was modified by the law reforms ordinance. There were provisos put in the law reforms ordinance that did not exist. So the law reforms ordinance did modify the rules.
Salahuddin Saab, the letters patent issue होते थे ना 1861 के आप निकालने बॉम्बे हाई कोर्ट, मद्रास हाई कोर्ट, कलकत्ता हाई कोर्ट के वगैरह वगैरह. मुझे लाहौर हाई कोर्ट का नहीं पता, but at least in some of them, maybe also in the letters patent of Lahore High Court, there was a clause, a specific clause in the letters patent that these letters, provisions of these letters patent may be amended by the Indian legislature. There was a specific grant of power going back to 1861. So, letters patent appeal, it is an appellate provision and under letters patent की position बिल्कुल फर्क थी. दूसरी बात, ये jurisdiction होती है ना. Appellate power is a substantive power. आप जरा kindly देखिए जो concurrent list में जो power था equivalent, जो entry थी equivalent to 55, jurisdiction of all courts except the Supreme Court. So that included the jurisdiction of high courts. In terms of legislative competence, I'm not speaking otherwise. In terms of legislative competence, an appellate power is regarded as residing in the relevant procedure, the entry relating to procedure. So, in a the structure of the Government of India Act 1935, where very carefully, the federal court was shielded from the legislator. It's a different thing.
Mr. Salahuddin, this was my question right from the beginning. ये जो Ordinance 72 के तहत, right from the beginning ये जो Ordinance 72 के तहत, देखिए Ordinance 72 में 199 article Constitution का है, उसमें appeal की power दी against the order of the High Court, whereas Article 199(5) restricts the High Court from calling into question any order of the High Court. उसकी मौजूदगी में लॉ रिफॉर्म ऑर्डिनेंस को 270 में प्रोटेक्शन दी गई. क्या कॉन्स्टिट्यूशन मेकर ने ये नहीं समझा कि ये ठीक लॉ है, बावजूद इसके कि कतगन है आप इसको अपील की रेमेडी दे दो, इसके बावजूद इसके कि 199 में एक रेमेडी सुप्रीम कोर्ट में भी उसको अवेलेबल है. तो इस तरह दो अपील की रेमेडीज मिल गई. तो उस एनालॉजी पे अगर हम जाएं कि कॉन्स्टिट्यूशन मेकर्स तो इससे एग्री कर रही हैं, कोई बात है, by even by ordinance you can provide a remedy.
An appellate right.
Why not through a
I'm in respectful agreement with your lordship. Now, the other thing that I wanted to point out is that the Civil Procedure Code, all the different provincial assemblies have amended it, made wholesale amendments to it in the last 5 years, since there's been a bit of a laggard. But the rest of the provinces and the parliament in case of Islamabad, they've made huge changes to the CPC. And those changes have been given effect over the previous civil court rules that were framed by the respective high courts. So to say that any legislative interference in the rule-making power of the courts, of the high courts, or the Supreme Court, to say that that is not permissible, then all those amendments in the CPC will also need to be struck.
All those amendments have been made in the substantive part of the
legislative
CPC.
competence to do that for other courts, but not for the Supreme Court. There is a clear distinction.
Lord, but 191 and 202 are in identical terms. The principle applicable here would apply then with equal force.
One question, this is like one Karachi lawyer to another Karachi lawyer. because you mentioned the Sindh Chief Court rules original side. उसमें एक rule है कि to the extent that the first schedule of the CPC clashes with the Sindh Chief Court rules original side, the original side rules will take precedence, will supersede. So on your theory, would this, whatever rule it is, would this be ultra vires?
Well, Lord, that as far as that was...
On your theory, it would seem that it is ultra vires.
Well, Lord, that as far as I can understand is because of general and special law. The procedure for the CPC is the general, and for the High Court in particular, it's
बात तो competence की है ना, बात तो फिर competence की है. आप कहते हैं कि जी it's the reverse. The competence is the reverse. Law can override the rules, but not vice versa. मैं आपको एक मिसाल दे रहा हूँ. कब आए थे हमारे ये original side 1944 के है ना?
1930
rules में original side.
I've forgotten the exact
lawyers, Zubairi Saab.
I think Abid Saab might remember.
Anyway, that's on the lighter side.
आप कितना टाइम ले रहे हैं आप?
Sir, I'm just trying to wrap up.
जी बताएं.
जी sir.
क्योंकि there is a mutiny against the master. Murmurings of a mutiny against the master.
My lord, my colleagues who are waiting have also assured me of great retribution if I don't wrap up quickly.
No, but there may be a pen-down strike. You cited the example of Nepal. So a similar strike has been threatened that you are the last counsel for the day and the rest we'll hear tomorrow, inshallah, at 11:30. So please wrap it up now.
I'm wrapping up, sir. Sir, एक और चीज मैं जरा दिखाना चाह रहा था. If your lordship sees, जहाँ law का लफ्ज है, because an expansive interpretation of law was urged. If your lordship will see, जो 175(1) की power है, such other courts as may be established, and that is why we have to look at the context of each of the provisions, such as other courts as may be established by law. Obviously, over there, the law could not be judicial precedents of this court. While law is normally has a... Now, similarly, 175(2) में, फिर उसी तरह सर 192 में जो power है to that the High Court shall have as many judges as may be prescribed by law. Again, it could not be law that is prescribed by any judgment. So, the argument that 191 has to be treated as this grand provision that includes everything and rules and bylaws and all that, I would humbly submit that that is not borne out.
The law is made under Article 175(2). The pursuant to Article 175(2), this law has been made. जो उसमें लिखा हुआ है, read with Article 191.
बिल्कुल. अब सर, now
ये जो इसमें आप 2 को पढ़ेंगे ना, इसको 187 के साथ पढ़िए. 187 में इसका रेफरेंस है.
जी सर.
187 पढ़िए.
Subject to clause 2 of Article 175, it recognizes
ये jurisdiction confer जो हो रहा है ना 175(2) का, it is read with Article 187 as well. उसी का रेफरेंस है वहाँ.
बिल्कुल.
कि जो भी सुप्रीम कोर्ट पावर एक्सरसाइज करेगा, that is subject to Article 175 sub Article 2.
बिल्कुल. I agree, sir. सर, एक और जहाँ तक इंट्रा कोर्ट अपील की वो जो सेक्शन 5 वाली इशू है, I just wanted to briefly point out the occasions where Parliament has created an additional appellate jurisdiction on this court over and above what is written in 185, Sections 9, 155 and 202 of the Election Act, Section 44 of the Competition Act, Section 48 of the Legal Practitioners and Bar Council.
What are you referring to, sorry?
The power of Parliament to confer an additional appellate jurisdiction on this court, which is not anywhere mentioned in 185. 185 talks of only orders of the High Court, but they have created appeals coming from different forums, and those, the constitutionality of that has never been...
Including contempt of court.
Yes, sir. And finally, Section 19 of the contempt of court.
Contempt of court was the ordinance. It was saved by 270, and it was saved in the 18th Amendment.
Yes, sir.
So that's a different
But
category.
again, what I would urge is that the savings is retrospective validation. As this court has held that the Article 268 up till 270, AAA, etc., they don't mean that a law that is saved can continue despite being in violation of some constitutional provision. So the Contempt of Court Act might have been saved because it was promulgated.
Which was the third law, election competition? Which was the third one?
Sir, Section 48 of the Legal Practitioners and Bar Councils Act.
So in Section 54 of the Land Acquisition Act also.
Ji, sir, bilkul, that is an example. And that is an example of a provincial law creating.
आपने कहीं लिखा, आपने सारी चीजें लिखी हैं कहीं?
जी सर.
अगर नहीं लिखी हैं, ग्लेस दे दीजिएगा.
जी बिल्कुल सर. They are in my concise statement.
If I could just ask a question, is there no difference between creating a right of appeal to the Supreme Court from some subordinate court's order or forum's order, as opposed to creating a right of appeal at the Supreme Court from an order of the Supreme Court itself? As I see it, there is a difference. So the examples that you give are a little different. This is bringing a right of appeal to the Supreme Court, whereas we are looking at the right of appeal against an order of the Supreme Court in a jurisdiction given and spelt out by the Constitution. So the question here is that if the Constitution has provided for a right of appeal or has not provided for the right of appeal, can by way of statute that right be created in the Constitution? I mean, there is a difference. Looking at laws which provide a right to the Supreme Court is something a little different than what this case is about over here. And these examples, at least I don't understand how these examples would help your case over here.
The law that specifically creates an intra-court appeal is the Contempt of Court Ordinance.
Yes,
Section 19. It creates an intra-court appeal from this court to a larger bench of this court. So that is a precise.
That is a precise, but there is an explanation and a judgment that deals with that specifically, which again doesn't answer the question that we have asked you again on competence, and I'm asking you how an amendment to the Constitution can be made, or a provision which is not given in the Constitution can be made through ordinary law.
Your leadership will appreciate that Article 204 of the Constitution does not create any right of appeal. It only allows Parliament to regulate the punishment of contempt.
And
in
this
that
word,
regulatory power and appeal under Section 19.
This word regulate has been explained that it means conferring of some form of rule-making legislative power. There are judgments to that effect. So the word regulate has been used. So election ki provision mein, the word regulated by law is used, as Mr. Bhandari had pointed out.
So
again, it is a little different.
My humble submission.
Salahuddin, ye bataiye, give an example. How can the jurisdiction under Article 184(3) uski expansion kaise ho? You see, this is a precise question. Secondly, there are various jurisdictions of the Supreme Court. It is not that they all separately would be expanded. That is why, you see, jo settled principles hai, whether wo hamari judgments hai, that these entries have to be interpreted liberally and broadly. But sirf itna bata dijiyega, give one example how through law can Article 184(3) jurisdiction uski expansion kaise hogi wo bata dijiye.
Sir, meri submission, and this will be my last submission on this issue of appeal, is that even if a presumption of finality is attached to the 185 appellate jurisdiction, and I think that is quite reasonable, it cannot just keep in endless loops of appeals over there. A presumption of finality exists for appellate jurisdiction. That presumption is not there for the exercise of original jurisdiction by this court. And the reason for that is, sir...
I didn't understand.
Sir, even if it is said that 185 ki jo appellate jurisdiction hai, there is a presumption of finality attaching to it, because of which Parliament cannot create an additional statutory appeal over and above an appellate case already decided by this court. That presumption can certainly not be applied to the exercise of original jurisdiction under 184(3).
Okay.
And the reasoning, one submission that I'll make on that point is, sir, and it carries on from what Mr. Zaid Ibrahim had said. Article 2A and वो जो दो judgments cite की थी, Federation of Pakistan versus Public at Large, etc. The right of appeal is part of the injunctions of Islam. Now, if you have two possible constitutional interpretations, one allows the parliament to create a right of appeal, one says that no, parliament cannot create a right of appeal. The interpretation that is in consonance with the principles of Islam is to be preferred.
Is it enlargement of the existing jurisdiction?
My Lord, enlargement ke hawale se, I have a very plain and simple understanding. Enlargement means to make larger. It can mean that the scope of an existing jurisdiction is made broader and deeper. It can mean that new things are added to that jurisdiction. It is to be treated, it is a legislative entry after all. It is to be given an expansive meaning.
Mr. Salahuddin, in right of appeal, what do you say about the retrospective effect to the right of appeal?
Jesus, that is...
And there is no end to this. There is no cut-off date.
My Lord, that is...
It will start from 1973, from the date of the Constitution, or what?
My Lord, I'm going to take a slightly cowardly way here. There is one interpretation that your Lordship...
इसके साथ ये बता दीजिएगा, क्या जिन cases में review already exercise हो चुकी है, will they be also covered?
No, sir. They will not. Now, one interpretation that can be taken is it's a remedial statute, etc. It's meant to confer, and then if it's remedial and retrospective effect back to 1975. The other more limited interpretation that could be taken is, sir, that it is only meant to open the door for those cases that were decided within the 30-day limitation period mentioned in section 5. So it would apply to those cases that had been decided 30 days prior to the promulgation of the Act. That is the limited retrospectivity.
This is not the interpretation of this law. This is prior to commencement of this Act. This is open-ended, you see. This is one of the interpretation which you are giving. Within 1 month, you decide here that can be taken into consideration.
But to save the constitutionality of the law, your lordships are empowered to give it a limited reading or even read it down to that. Now, two more things and I'll just wrap up, sir.
You are on the last thing now. I said you were on the last thing.
Yes, sir. These are just for the specific provisions, the issues with the specific provisions that have been raised. I'll run through them, sir. एक बात की गई थी, sir, कि the gatekeeping imposed by section 3, that the committee is an administrative committee. It gatekeeps the exercise of judicial powers by this court. Now, 1 month ago, sir, I filed a petition for the Bar Council on challenging the amendments to Official Secrets Act and the Army Act. The registrar returned it on the basis that this is not of public importance and no question of fundamental rights is involved. That appeal will lie, and it's an appeal conferred by the procedural rules. It's an administrative appeal. It will lie to a single judge of this court, and he may accept it or reject it, and I'll have no remedy against that. Now, if the registrar with the single judge in chambers can act as an administrative gatekeeper over the exercise of judicial power under 184(3), I fail to understand why a committee cannot do so.
The right of appeal lies to the chamber.
Yes.
In case of registrar, if the committee rejects, then where the appeal lies?
Sir, but your lordship will appreciate
single judge.
The right of appeal to the single judge in chamber is not a
No, it is
judicial.
Article
It's only an
184.3.
administrative.
One Article 184.3, the committee will decide whether it is a case of public importance or not. In case they reject, in case registrar rejects the appeal, then the appeal lies in chamber to a single judge of the Supreme Court. ठीक है? यहाँ पे अगर कमेटी ने रिजेक्ट कर दिया, उसके बाद फिर वो कोई रास्ता नहीं है उसके लिए. वो फिर जो कमेटी has rejected, then there is no right of appeal unless we will read it down.
Yes, yes, that is.
आप कह रहे हैं वहाँ पे एक जज है, यहाँ पे 2-3 है, तो आपका क्या contention है कितना?
I don't, and perhaps there is perhaps one logic behind it, because Article 199 की जो jurisdiction है, that is available. The remedy is available to me as of right if I am an agreed person, etc. जो 184(3) की जो jurisdiction है, that is a discretionary. Sir, एक minute.
नहीं तो यहाँ जो अपील आएगी ना, it's not an appeal deciding a list. It is only deciding the competence whether it should be heard or not. Otherwise, the list will remain alive. You can take it in a suit, you can take it in a writ jurisdiction. I don't know, whichever way you want to take it, but we don't kill the list. I mean, it's okay.
Exactly.
You don't meet the test in our opinion. That opinion, your point is that if one judge can get it wrong, the registrar gets wrong, you have it before one judge.
still go
Here the 3 judges get it wrong. So,
and because your lordship will appreciate that when I come in 184(3), I can show to your lordships that I have. Sir, let me just complete this and then I can show to your lordships that I have a case of great public importance.
How are you
It
reading
engages
this right in
fundamental
Section
rights,
5?
But your lordships may still
How are
decide not
you-
to
how are
entertain it
you-
and send me back to the High Court.
How are you reading this right in Section 5? Section 5 says, by an order of a bench exercising jurisdiction under 184(3). So how are you reading the right under Section 3 that if you are denied that case is not fixed, that appeal will come under Section 5? It doesn't come under Section 5.
I'm not reading that, Your Ladyship. I was talking about the fact that an administrative gatekeeper was present under the old system for 43 years, and it is present.
Section 3 के under there is an administrative
Please
party
read
exercise.
Section 3. Please read.
Any matter invoking exercise of original jurisdiction under Clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under Section 2 for examination. And if the committee is of the view that a question